You might have heard about the implied consent warning and what that means in relation to a DUI case. Well, the implied consent warning is essentially this. Each of us, the law views driving as a privilege and not a right. And by virtue of having our driver's licenses, we have automatically given our consent, our implied consent, to submit to a chemical test of our blood, breath, urine, or other bodily substances if lawfully arrested for driving under the influence. The language of the implied consent notice essentially states that if you are arrested for driving under the influence and you refuse to submit to chemical testing of your blood, breath, or urine, then the officer will initiate a suspension of your driver's license. But that's a civil administrative process that we can appeal and challenge. The warning also states that if you refuse to submit to a chemical test of your blood or your urine, that refusal could be used against you in court. Well, this language is subject to challenges. It's already been challenged at our Georgia Supreme Court. In the Awad case, the Supreme Court held that the refusal to submit to a urine test cannot be used against you. Currently before the Georgia Supreme Court is the Randall case, where the court is determining whether the submission to a blood test, refusing that, can be used against you at trial. And our office has been involved directly or indirectly in all of these cases, challenging the constitutionality of the implied consent warning. As it is currently written, there is no way that this warning is constitutional. Each of us enjoy rights against self-incrimination, and we enjoy rights against unreasonable searches and seizures.